112. Will my displaced workers have any trouble getting unemployment insurance?
Unemployment insurance is the only tax that is under your control as an employer. It's important to remember, however, that your company doesn't determine whether an employee wins an unemployment claim, the state does. Of course, you can contest an unemployment claim, but you probably don't want to do that after a layoff. After all, the purpose of unemployment insurance is to help employees who have lost their jobs or suffered some form of wage loss through no fault of their own. Unemployment insurance is meant to be a very generous and liberally construed benefit for American workers. According to the system's logic, if unemployed workers are denied interim benefits, the United States may revert to a nation of soup kitchens and shanty towns. As a result, administrative law judges award benefits fairly liberally. Understand that each state legislature has discretion in determining how to implement federal unemployment guidelines. As a result, certain states have very liberal interpretations of the application of unemployment wage replacement insurance, while others have stricter guidelines. Still, there are some twists and turns in the unemployment insurance game, so let's take a brief look at the basics regarding layoffs and terminations for cause. It's important to understand what it means to be the moving party. You must be able to differentiate between a voluntary quit and a discharge. Finally, understand that you can generally challenge an ex-employee's claim for unemployment if you can prove misconduct or a quit without good cause. Tell me more. The moving party concept is critical to understanding how to manage unemployment taxes. Generally, the party that picks the last day that the employee works or receives wages is the moving party. If employees pick the last day that they work, via resignation, then they are the moving party. If the company dictates the last day that an employee works, via layoff or termination, then the company is the moving party. Therefore, in order for ex-employees to receive unemployment insurance, they must demonstrate that the company was the moving party and that they are actively engaged in the job-finding process. Let's look at some examples. If you lay off an employee on May 30th and give her same-day notice, then your company is the moving party. Ex-employee claimants should be able to successfully collect unemployment because they lost their jobs through no fault of their own. If an employee gives you 2 weeks' notice of her resignation because she's found another job and she works through the notice period, then she's the moving party. Any claim that she files for unemployment will probably be denied. If that same employee gives you 2 weeks' notice of her resignation because she's found another job and you send her home that day without paying her through the notice period, then you're the moving party. In other words, she was willing to work the additional 2 weeks through her notice period, but you caused her to lose wages prematurely by sending her home. Therefore, she'll probably be awarded a claim for unemployment. If an employee gives you 2 weeks' notice of her resignation and you immediately place her on vacation and charge the balance of the 2 weeks' vacation against her accrued vacation, then you're the moving party. The reason is that you'll have accelerated the separation date in that an actual wage loss will have been suffered. The employee would have otherwise been entitled to accrued vacation pay up through the 2-week notice period. Again, a claim for unemployment would probably be awarded. If an employee gives you 2 weeks' notice of her resignation because she's found another job and you send her home that day but continue to pay her through the notice period, she remains the moving party. After all, no actual premature wage loss will have been suffered. The lesson. The best advice to be gained is that when an employee gives notice to leave on a specific date, you should always get a resignation statement indicating the real, substantial, and compelling reason that the individual is resigning. You should then continue to pay wages as normal through the notice period. A voluntary quit occurs when an ex-employee is the moving party. However, if an employee quits for good cause is subject to legal interpretation by the various states. Of course, he'll most likely collect unemployment insurance benefits. For example, a quit due to intolerable working conditions or due to relocation from Boston to New Jersey may be deemed a constructive quit, and the individual will most likely receive an unemployment insurance award. A discharge, for reasons other than misconduct, on the other hand, occurs when you, the employer, terminate the individual. In such cases, you'll be the moving party. Therefore, the claimant will most likely receive an unemployment insurance award. If, for example, you terminate a worker for mere inefficiency, unsatisfactory conduct, good faith errors in judgment, or ordinary negligence in isolated instances, then courts will construe your termination decision as a straight discharge and award benefits.